Welcome to Sullivan & Cromwell Sidebar, where we talk to different litigation partners about some of the most interesting legal issues they've seen in their career and what's on the horizon, among other topics. I'm Jay Clayton, Senior Policy Advisor at Sullivan & Cromwell, and today I have the pleasure of talking to Annie Ostrager. Annie is co-head of our employment litigation practice and has been a partner since 2018. I know firsthand she has seen a number of very challenging issues, and many of you have probably not seen them because she's made them go away. Annie, let's start with, what are some of the most interesting issues you've worked with and cases throughout your career?
Thanks, Jay. Nice to talk with you today. I'm very fortunate to have a diverse practice at S&C, and this has been the case throughout my career here. I've worked on a number of high-stakes civil litigations, including the litigation on behalf of JPM, in which plaintiffs tried unsuccessfully to redefine a syndicated loan into a security. I've worked on high-stakes government investigations and civil litigations for Allianz, which we talked about during our crisis management webinar. And I've worked on high-stakes matters that, as you mentioned, were never made public because that was the ultimate goal for the client in resolving those matters.
Your career has really blossomed incredibly quickly. You were made head of the employment practice early in your term as a partner. What brought you to that role? What have you focused on? And how do you feel about leading this important part of our practice?
I feel very honored to have the opportunity to lead this practice, and I think the increased focus on corporate employment issues over the last couple of years has really amplified the consequences companies face, as employment issues can quickly escalate to reputational and bet the company issues, or turn into government investigations or civil litigations, or take any number of paths. So one of my goals as a leader of this practice is to deliver to clients advice that's informed by my generalist upbringing at the firm and multi-specialist practice to promptly identify and, if they materialize, mitigate these types of issues. Having experience litigating high-stakes civil matters and handling government investigations, I think, sets our practice apart because it allows us to handle matters across a wide spectrum of issues with expertise that is employment-specific, but that's also broader. We've also seen white-collar lawyers starting to be hired for employment issues, which makes sense to some degree given the gravity given to this area of the law now. But our practice has this experience baked in, especially in partnership with some of our other partners in our criminal defense and investigations practice.
Yeah, I want to pick up on the generalist approach and talk about that. In my role as a member of a couple of public company corporate boards, it's terrific when you have a great litigator after a problem has arisen. But even more important is forward-looking advice that helps you avoid a problem. Now, it may not be the bread and butter of what people think about in terms of a litigator, but can you talk about developments that you're seeing on the horizon and what steps corporations should be taking to avoid having Annie Ostrager be there for years?
Yeah, I was actually just talking about this with a client I was in court with yesterday who said to me that she only realized how important that is when we were already in the midst of a crisis we were handling for her and her company that sort of came up on a late Friday night into a Saturday morning. But I couldn't agree more that knowing your lawyers and knowing the issues before you're in that situation is really valuable and important. In terms of legal issues that are on the horizon or that are already here in the employment space, I would name a few. First, non-competes and other restrictive covenants have really come into sharp focus for companies. S&C, as you know, successfully helped secure a permanent injunction with nationwide applicability, preventing the FTC's rule banning non-competes from going into effect. But even with that injunction, the tide is turning against the use of restrictive covenants in many states, including New York. And we've seen that that's leading to an increase in trade secrets litigation, some of which we're handling, especially in industries in which confidential information is really core to the business. Second, I would say whistleblowers is a hot topic. The Supreme Court weighed in on the standard for a whistleblower claim last term. Agencies are expanding whistleblower protections, and the SEC has brought a series of enforcement actions alleging that employment agreements and other documents with confidentiality language impede whistleblowing activity. And we're working on some of these investigations and also seeing this come up in investigations that start off on a totally different topic. I would also say spillover effects from the Supreme Court's decision striking down race-conscious admissions policies in the university context has been top of mind for a number of our clients as they look at their DEI programs and practices. And finally, a continued focus on corporate culture issues, and we have a robust practice in this space. And as I mentioned, companies are increasingly viewing these types of matters as high stakes, important to their reputation, and that's both because of the government's increased scrutiny of what was previously treated as an internal employment matter, and because of their other stakeholders' views on that type of conduct.
Sure. Well, that's a lot, right? Non-competes, whistleblowers, corporate conduct, and diversity and inclusion programs are all sort of front of center in how do we move forward. That leads me to the generalist approach. And I think this particularly came out in the FTC non-compete case. By being a generalist, it actually means you see a lot of different types of situations. And I think what happened in that case and why was there a nationwide injunction? It's because a single blunt approach across all different types of organizations and all different types of employment relationships just didn't make any sense. Can you talk about how your generalist approach, or I would say broad experience, helps you litigate these matters and helps you advise companies in these areas?
Yeah, I mean, I think the generalist model is really core to my practice, and the high stakes matters we involve often require a multidisciplinary approach. That case is a good example. But it's really one of the ways in which we draw on one of S&C's greatest strengths, which is our interdisciplinary approach, our multi-specialist approach. And I think you've heard me describe this a little bit, but so maybe a different way to talk about it is that as a generalist, I feel I've been trained to focus on a client's priorities and needs in any given legal exposure, and then think about the relevant law as tools that come into play to get the company to where it needs to be. So some clients will want to fight, some clients will want a quick resolution, especially if reputational issues are at stake. And I think the generalist approach means I've seen a lot of different things, and I understand that there's not going to be just one size fits all.
So how did you learn to, and this is not something you learn in law school, how did you learn to put yourself in your client's shoes and think about things from your client's perspective? You know, what does she want? What are her objectives? What's her risk tolerance? Talk a little bit about that.
It's a great question. I mean, in part, I think I learned it from the mentorship of partners who are more senior than I am here, who I've worked with over the course of my career. And in part, I think it comes from seeing a lot of different types of matters and understanding that the best resolution for a client really depends on the client's business, the client's priorities, and it's not going to be the same in every situation.
Yeah, and I think understanding those client needs, that client perspective, helps promote a really good working relationship. I know that's important to you, but maybe talk about one or to relationships that you've had? Don't name names, you don't have to do that, but that have really meant something to you, because that kind of deep personal relationship, I think, makes advising clients much more rewarding and much more effective.
I couldn't agree more. I will say one example of that comes from a case that I started working on when I was a senior associate, actually. And Karen Seymour was the senior partner handling the matter. And over the course of the matter, she left the firm to go be the GC at Goldman Sachs. And as she was about to leave, we were talking about the case, which was a big, high-stakes billion-dollar exposure for our client. And I said, Karen, who's going to lead this matter after you leave? And she said, you are, Annie. And it was an incredible opportunity for me to take on a leadership role early in my career. And the relationship that I forged with the in-house lawyer was a very meaningful, significant relationship for me. That lawyer moved on from that client. She's been at actually 2 or 3 different places since then, and I've continued to work with her across a whole variety of matters, none of which are related to each other, but we work together because of that relationship more than anything else.
Yeah, that is terrific, and kudos to Karen. One of the things that I like to say to people when we're talking about who's going to handle something is, well, if not you, who? Because I think many of our senior associates, many of our early partners can do a whole lot. And it's that opportunity to do something with the confidence that you have a relationship with the client, with the confidence that you have a number of partners you can turn to easily, that really helps you grow. Let's wrap up with the advice that you would give to associates who look to you as somebody that they want to emulate and learn from.
My first piece of advice is actually to develop those types of strong relationships, both inside the firm and externally. I feel extraordinarily fortunate to have been mentored by really brilliant, strategic, dedicated, and passionate lawyers at the firm who've challenged me to do exactly what you described, supported me, and really taught me to be a lawyer. So that's the first thing that I always say to more junior lawyers who are just starting off in their career, and it can make a huge difference in the work you're doing, and it can make a huge difference for your clients when you have those relationships. I would also say stick with it, and that advice goes both for your career and your advocacy. I've had many matters where we make an argument that we know is right and should prevail, and it doesn't carry the day the first time you make the argument. And I think lawyers at the beginning of their career have an instinct to just sort of move on or try something else. And I've had a lot of success and been taught by lots of people here that you have to actually persevere in making those arguments and stick with it. And of course, you have to do excellent work, learn to anticipate the needs of internal lawyers and clients externally, and earn the trust of those you work with.
Well, Annie Ostrager, we know that you're a great lawyer. We also have now learned that you're a super mentor and counselor, someone who's able to put themselves in the shoes of others. Thank you for joining S&C Sidebar.